This question comes up a lot for potential clients as a creditor or even a debtor, is what is the consequence for hiding assets or hiding financial transfers? And it's more of a legal question than an investigative question. So remember, we're not attorneys, we're not giving you legal advice, but we can tell you what we've seen in the many cases that we work with as an investigator. The big caveat to this is when you're asking about hiding assets and is it a liability, are there consequences, the first question is, who are you hiding it from? If you're hiding assets from, in general, the general public, as long as you're not doing anything illegal, there's usually not any consequence for hiding an asset. The trouble comes in when you're hiding an asset from a creditor or the government or bankruptcy or a spouse in a divorce. There is a legal term called fraudulent conveyance. So if you are involved with any dissolution of marriage, partnership, lawsuit, loan contract, and the assets are pledged or belong to another party, and you start moving assets around and selling them to people or quit claiming houses, the other party can come forward and say that you've committed what's called a fraudulent conveyance, meaning that you've taken an asset that somebody had a legal right to, either as collateral for a loan or as community property in a marriage or as security for a debt or a partnership, and you've now transferred that asset to a third party. And that transfer was fraudulent because you didn't have the rights to transfer that asset. Now, the asset doesn't necessarily have to be physically documented with a loan contract against it. There are many statutory contracts or statutory ownership or claims that exist. For example, when a person dies, if a relative sells off some of their assets, we get this a lot on the vehicle titling side. Somebody's grandfather dies and they had an old car in the barn, and they took that car and they sold it to a third party. Well, the problem comes in, technically when somebody dies, unless there's a will and a probate, the assets first have to go to pay any debt. So if the grandfather had $3,000 owed on a credit card, before any of the assets go anywhere, that credit card's got to get paid. And if you start squirreling away assets or transferring them, that can be considered fraudulent conveyance. Remember, we're not attorneys. You have to check this with a qualified attorney. Most people do this really unintentionally, but you have to be aware of what the rules are. In addition, a lot of times there's not going to be any consequence because that credit card company is not going to ever check what happened with the car. Where it comes into a problem is if there is some event that creates a trigger for an asset search. For example, if somebody files bankruptcy and the bankruptcy trustee runs an asset check on the person, if they find a lot of assets were transferred right before it, that might be a problem. In a divorce, it's good practice to run an asset search on the other party in the divorce and find out not only what assets they have, but which ones were transferred recently. Look, if a spouse in a divorce sells off a company 6 months before the divorce happens, there could be a claim that that asset has to be brought back in, or the value for the asset has to be brought back in. So hiding assets by itself usually is not a criminal or problematic event. It's the reason you're hiding it becomes a problem. If the court tells you you have to preserve assets, if you have a claim of litigation or a lawsuit, and the court says, while this lawsuit is pending, you need to, hold all the assets, freeze all your assets, and you start switching stuff around, that could be considered something against the court. They can hold you in contempt. They can even file criminal charges. Another example is when you have a loan against something and you sell it, whether it be a vehicle, whether it be equipment on a UCC. We had a case few weeks ago where there was a large piece of construction equipment, drilling rig, that was sold by a party out of state to somebody else, and this was several $100,000 piece of equipment. Well, the person who purchased it was trying to get documentation, a title for this equipment. And in doing some research, we found that the seller had all kind of judgments, tax liens, financing against their business, and the finance contract was a blanket contract that said it covers all equipment owned by the business. It was a blanket lien against all equipment. Now, it wasn't filed specifically against each serial number of piece of equipment, but it covered everything. So when the seller was looking to generate some cash because they were a little short on money, they started selling off equipment that this loan had funded with capital. So if you're thinking about, is this going to be illegal or have consequences about hiding an asset, it probably is, because the reason you're asking about it is probably because of the purpose you're wanting to hide the asset. And the most important thing is to get good legal advice from an attorney. Don't take advice from an internet chat group, your buddy on Facebook, a private investigator like us. Get some ideas, but don't take any action until you get good qualified legal advice, because your scenario might be perfectly fine to move an asset, but on the other hand, it might not be fine. So you don't want to get caught in the middle with having done something that inadvertently gets you into trouble. Leave some comments below. Let us know what you think or what other questions might be worth talking about.